Good afternoon, and it's a pleasure to be back here in The Hague, and thank you all for your support for Israel as we have to deal with a whole variety of enemies. So I'm going to talk about the International Court of Justice and the advisory opinion requested by the United Nations General Assembly. Andrew has already provided some introduction to this. This slide actually covers various things that he's already mentioned. Just to pick this up, the International Court of Justice has two basic jurisdictions. One for contentious proceedings, but only if the parties to the dispute have agreed, either in a treaty or specifically for that particular case, and its decisions in those contentious proceedings are generally binding. The second jurisdiction is for advisory opinions on a request by a UN body, normally the UN General Assembly, but it can be various other bodies, on any legal question. So you might think, well, that doesn't mean facts, but as the Latin tag goes, ex facto jus oritor, from the facts arises the law. And in theory, an advisory opinion is not binding, but in practice, an opinion of the International Court of Justice is treated as of considerable weight, both in legal circles, but also even more so, I would say, in the public domain, in the media, with the public. It's not, people don't necessarily understand the difference between a non-binding opinion and a binding determination. Participation in the International Court is limited to states and intergovernmental organisations. NGOs can submit observations under Practice Direction 12, but they're not placed on the court file. They are made available in the court building, and of course you can publish them online or print them or try and interest the media in them and so on. But they're generally not considered at all by the judges. Just occasionally, sometimes they are, but generally speaking not. So very little opportunity for non-state actors to intervene. And that's actually quite a contrast from the International Criminal Court, which is rather more receptive to NGO submissions. So there are some general concerns where advisory opinions relate to bilateral disputes. This is not just a problem for Israel. Other states have found that it's a problem, including the UK. One or both parties may not have consented to the International Court having jurisdiction over the dispute, and yet effectively the International Court is ruling on the dispute. That undermines the principle that the jurisdiction to determine disputes is a matter for consent, requiring consent of the parties. The determination by the International Court may even be contrary to an agreement between the parties specifying a different form of resolution. It may also make the dispute more difficult to resolve. This is a well-known factor with legal proceedings, is that very often they really prevent the underlying dispute being solved rather than help. Having said that, though, the International Court's view on this, and you can certainly argue it, is, well, we're the lawyers, we're the judges, and it's not really for us to decide whether it's useful to have a legal proceeding. We leave that to the politicians, and the politicians in the United Nations General Assembly have taken the view that they did. That tends to be the attitude of the International Court. And then we have a really serious problem that the International Court may not be provided with full and accurate facts. And I'll come back to that because it's a particular problem when it comes to Israel issues. The United Nations General Assembly's request in this that we're discussing, it is at the end of a lengthy resolution which contains what we call in English idiom a kitchen sink of items, a sort of whole ramshackle array of largely false allegations. And I can't possibly go through them all, but I just picked out this one, which I thought was so striking, and to some extent it's symptomatic. They record with grave concern the UN Country Team report of August 2012, entitled Gaza in 2020, A Livable Place. Now, the Gaza population in 2012, when that report was written, was 1.64 million. 2022, 2 years later, after the date when it was questioned whether it would be a livable place, the population had risen to 2 million. And actually, the main issue covered in the 2012 report was water, and that was largely solved by desalination in the intervening period. Who developed and really brought on the technology making large-scale desalination practical proposition? Yes. Will the International Court pay any attention to the content of the resolution outside of the questions, all these prejudicial statements and allegations? I just don't know. But looking at the questions, you've got them in the folder in the Fiji written statements to the International Court, has copied them there. But if you just have a quick look at them now, and you might want to get out the Fiji memorandum so that you can, whilst I go through some of these points. There are quite a number of objections to the International Court proceeding in this way. First of all, it is a bilateral dispute, Israel and the Palestinians, and Israel has not consented to the International Court determining these questions. In a way, it contradicts the Oslo Accords, in which Israel and the Palestine Liberation Organization agreed to resolve issues by negotiation. There are false and highly contentious assumptions in the questions, and I'll look at that in a bit more detail in a moment. The questions are, in major areas, completely undefined, so you don't know really what they're asking. There is a raft of inaccurate, unreliable and partial information before the court, and I'll come back to that. The resolution results from and forms part of the UN's discrimination against Israel. And actually, we consider, and there's quite a strong argument, and a very famous international lawyer, Professor Jennings, wrote an opinion about this in the past relating to other activities of the UN, that the UN Charter does actually require the members of the UN to be treated equally. Israel is the subject of massive discrimination against Israel, and this resolution really does form part of that continuum. For that reason alone, we would argue, and indeed have argued in a Practice 12 submission we've made to the International Court of Justice, that the whole exercise is actually based on illegality and shouldn't be countenanced for that reason. But looking more specifically at some of those points there are false assumptions in the questions. The allegation of ongoing violation by Israel of the right of the Palestinian people to self-determination. Well, there are lots of things that one can say about that, notably the quite significant extent of Palestinian self-determination that already exists, or at any rate existed prior to the 7th of October. And of course still exists to a large extent in the West Bank. But I just flag this because I think this has been underreported. An overwhelming majority of Arabs of East Jerusalem, at least according to some polls, prefer Israeli rule of the United City. And that I've taken from a poll of the Palestinian news agency Shifa in December of 2021. I don't think there's been any major similar exercise since then. And if you don't like Palestinian news agency polls, I noticed actually that the Israeli census authority, the Israeli Statistical Authority, part of its recent survey included a question of are you satisfied with life? And 86% of Arabs in Jerusalem said that they were satisfied with their life. So it should not be assumed that self-determination means for Arabs in the areas administered by Israel or governed. Jerusalem, of course, is sovereign territory as far as Israel is concerned, the whole of Jerusalem. It should not be assumed as just about every submission that was made in the International Court assumed that the Palestinians actually want a state, and all the Palestinians want a state, including Jerusalem or East Jerusalem or whatever. It's not necessarily correct. And then you have the assumption prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967. Gaza, before October last year, was that occupied? Not according to any honest application of the normal rule of international law, that occupation is when you have control of the territory, and according to the European Court of Human Rights, that means boots on the ground. And prior to October 23, I don't think on any legitimate interpretation of the international definition of occupation could it possibly be said that Israel was actually in occupation of Gaza, whatever might be argued in the West Bank. And of course the only annexation that has taken place has been the annexation of East Jerusalem, which we would argue is entirely justified, not just because the overwhelming majority of the population of East Jerusalem prefer the continuation of Israeli rule, but also for a whole series of other grounds based on international law. And then the questions assume measures aimed at altering the democratic composition, character and status of the holy city of Jerusalem. So regarding demographic composition, the Arab population of Jerusalem has increased 5.5 times since 1967, and from 26% of the total population of Jerusalem to 39%. So where is the measure? I think one might say that Israel, the Israeli government, has made some attempt, somewhat unsuccessfully, to, with only partial success, to preserve the 150-year-old demographic Jewish majority of the city of Jerusalem, but it certainly can't be said that there's been some kind of fundamental alteration in favour or against the Arab population. And more Muslims than ever before, talking about the character and status, more Muslims than ever before pray on Haram al-Sharif, the Temple Mount, 10 million every year. And then you have the undefined questions. They ask, what are the legal consequences arising from its adoption of related discriminatory legislation and measures? But they don't say which legislation and measures they're talking about. The International Court has expressed disapproval of slanted questions in some cases, but has been prepared to address them and to some extent rewrite them. But undefined questions are more difficult because if you don't know what the question is, you don't know what to say about it. And then you have inaccurate, unreliable and partial information. The UN Secretary General has a responsibility to provide information and documents, and has provided all UN documents relating to Palestine since 1967, 29,000 pages, but unfortunately they're largely inaccurate, unreliable and partial. I could go into some details, and perhaps if we have a bit more time later I can mention some examples of this, but the Israeli Supreme Court subsequently considered, after the International Court gave its opinion on the security barrier, the so-called wall case, the Israeli Supreme Court then had further cases relating to the routing of the security barrier, and they were pressed with the argument that the International Court had said that it was illegal to do it beyond the Green Line, beyond the Armistice Line of 1949, and in a superb judgment of President Ahron Barak, he showed that the facts on which the International Court had relied in the wall opinion, in the security barrier opinion, were incorrect and inadequate and incomplete. And he went through various parts of it, item by item, showing examples of how it was incorrect. Based on the evidence that this had all been based in the International Court on documents provided by the Secretary General of the UN, but based on the evidence that the Israeli court had before it from both sides, the Israeli court came to the opposite conclusion. So that is an example, as indeed Barak put it in his judgment, ex factis oriter jus. The law arises from the facts. And in this case, Israel, in the current case, Israel has not participated except to submit that the court should not give an opinion. And no other country has attempted to correct or balance the information or supported Israel's legal rights. A few have argued that the International Court should not give an opinion at all, but no one has put the merits of Israel's case. It was a very dispiriting and upsetting experience to watch some of the proceedings in the International Court and to read most of the written submissions and the texts of the oral submissions. It was very, very upsetting. What should the International Court do? Well, on procedure, we thought it had four options, and mentioned this in our submission. Provide an opinion without assuming any facts at all. Well, that's difficult because the questions assume various facts. Provide an opinion on the basis that the information provided is true and complete. Well, that opinion would be hypothetical, it would be unjudicial, it would promote racism against Jews worldwide, and it would make peaceful resolution even more difficult, because you would have those who would say, well, we can't settle for anything less than what the International Court ruled was our rights, and you would have other people saying, well, what the International Court ruled was completely wrong, it was based on false information and false arguments. Should the International Court investigate the facts itself? Well, in this case, given the breadth of these questions, it would be an absolutely monumental exercise, and the International Court doesn't have power to compel the production of evidence, so it would be a very difficult thing to do, and it's certainly not the normal way in which the International Court proceeds, and it hasn't proceeded so far in this case either. It's just heard submissions from a whole load of countries, most of which are based on false information, and it hasn't attempted to carry out any proper investigation of the facts. And indeed, there's no specific charge sheet of the kind that you will get in what is almost a quasi-criminal investigation. Or the court could decline to provide an opinion, and indeed that would be consistent with many rulings, many statements by the International Court, where it said that the question is whether the court has before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon any disputed questions of fact, the determination of which is necessary for it to give an opinion in conditions with its compatible with its judicial character. But the International Court has not declined any General Assembly request in recent years on that basis. It's just gone ahead despite that. And what should the International Court do in terms of substance? Well, we say it shouldn't provide an opinion at all, but if it does, this is what we proposed in our Practice 12 statement. There's no ongoing violation by Israel of the right of the Palestinian people to self-determination. Israel has not adopted measures aimed at altering the demographic composition or character of Jerusalem, and is entitled to exercise sovereignty over the United City of Jerusalem. In order to realise self-determination of the Palestinian people in East Jerusalem, West Bank and Gaza Strip, Israel and Palestinian representatives must ascertain the will of the Palestinian people in these areas and negotiate in good faith under the Oslo Accords to resolve remaining issues accommodating the rights of Israel and the Jewish people, as well as the Palestinian people. The court is not able to advise as legal consequences of the alleged discriminatory legislation, measures, policies and practices to which the General Assembly refers, since these are not specified in the questions. That's what we thought the court should answer, but what will it do? I don't think it will decline to provide an opinion. I think one possibility is that it might advise that any Israeli presence in East Jerusalem, West Bank and Gaza Strip, including military presence, is unlawful and must be ended immediately. I think that's quite unlikely. It is the Palestinian argument, but it will make the International Court look stupid given what happened in Gaza after Israel evacuated that area in 2005 without any resolution of outstanding issues, without dealing with the security issues, without dealing with borders and all the other issues that were reserved under the Oslo Accords for final stage negotiations. And I think this is the most likely possibility. I think the International Court is likely to advise that the Israeli presence in East Jerusalem, West Bank and Gaza Strip would be unlawful now, I think they'll say, but for the Oslo Accords, and only as long as the state of Palestine, as they regard it, accepts the continuation of the Oslo Accords. And in the meanwhile, Israel must comply fully with the Accords and international humanitarian law, and all other states, I think they'll say, and the UN, must not facilitate any violations by Israel. And that's likely to result in an intensification of BDS, boycott, divestments and sanctions, and other pressure on Israel. So thank you very much for your attention.